If you are a naturalized American citizen, something you believed was permanent may no longer be as secure as you think. For generations, becoming a U.S. citizen was considered the final step of the immigration journey, a lifetime guarantee that your status could never be questioned again. But as we move toward 2026, a new immigration crackdown is taking shape. And for the first time in decades, millions of naturalized citizens are being forced to wonder a frightening question. Could U.S. citizenship actually be taken away? Across the country, quiet but powerful changes are happening inside the immigration system. Internal policies are shifting. Old cases are being reopened. Files that have been untouched for years, even decades, are suddenly being reviewed again. And unlike past enforcement efforts that focused mainly on borders and new arrivals, this new approach looks inward, targeting people who already went through the legal process, already took the oath, and already built their lives as Americans. That is what makes this moment so different and so unsettling. For more than 26 million naturalized citizens, the assumption has always been simple. Once you become American, you stay American. Now, that assumption is being tested in ways most people never imagined. So, what exactly has changed? Who is really at risk? And how serious is this new enforcement push? These are the questions we're going to answer today clearly and honestly so you understand exactly what is happening and what it could mean for your future. To break all of this down properly, let me introduce myself. Hi, I'm Timothy, and welcome to U.S. Policy Updates, where we explain the latest immigration news in a straightforward, factual, and easy-to-understand way. If you've ever felt confused by complicated legal language or worried about how new policies might affect you or your family, you're in the right place. In this video, we're going to look at a major policy shift that is causing concern across immigrant communities, especially among naturalized citizens who thought their immigration journey was already finished. We'll go step by step, separating facts from rumors and helping you understand what is actually happening behind the headlines. And to really understand why this issue is creating so much anxiety, we first need to look at what U.S. citizenship has always represented and why that long-held definition is now being challenged like never before. For decades, American citizenship was viewed as one of the strongest legal protections in the world. Once a person completed the long immigration process, passed background checks, lived as a permanent resident, and finally took the oath of allegiance, that moment was considered the finish line. It symbolized stability, security, and belonging. A U.S. passport was more than just a travel document. It was proof that the years of paperwork, interviews, waiting periods, and uncertainty were finally over. Naturalized citizens built their entire lives around this belief. They bought homes, started businesses, raised children, and planned their futures with confidence, knowing that their status in this country was permanent. That understanding became deeply rooted in immigrant communities, passed down as reassurance to new generations. The message was always clear. Once you are American, no one can take that away. But now, for the first time in many years, that long-standing sense of finality is beginning to crack. Quietly behind government office doors, a different approach is taking shape. What was once treated as an extraordinary and extremely rare legal process is slowly being reshaped into something far more common. And that shift is what has millions of naturalized citizens paying very close attention today. The reason for this growing concern is a major change happening inside U.S. Citizenship and Immigration Services, known as USCIS. Traditionally, immigration enforcement focused on people trying to enter the country illegally or individuals who violated visa rules. The system was mainly designed to control borders and regulate new arrivals. But now, internal guidance circulating within immigration offices suggests that attention is turning in a new direction toward reviewing people who already became citizens in the past. Field offices across the country are reportedly being encouraged to actively search for old naturalization cases that could potentially qualify for something called denaturalization, the legal process of revoking U.S. citizenship. Instead of waiting for clear cases of serious fraud to appear, officers are being told to go back through previous files and identify possible problems. Once a case is flagged, it can be referred to the Department of Justice, where government attorneys decide whether to take formal legal action. This represents a fundamental shift in philosophy. Citizenship review is no longer only about obvious criminal activity or national security threats. It is increasingly about re-examining paperwork, statements, and applications that were approved many years ago. For naturalized citizens who believe their immigration story had already ended, this feels like the ground moving beneath their feet. And what makes this change even more alarming is the scale at which it is now being carried out. Internal targets reportedly suggest that immigration offices should be identifying between 100 and 200 potential denaturalization cases every single month. That means thousands of old citizenship files could be reopened and questioned each year, something almost unheard of in the past. To understand how dramatic this change really is, it helps to compare it with history. For many years, denaturalization was used only in the most extreme circumstances, cases involving clear and intentional fraud, serious crimes, or threats to national security. It was considered a last resort legal tool, not a routine enforcement strategy. In fact, over roughly an 8-year period starting in 2017, the total number of denaturalization cases filed across the entire United States was only about 120. That averages out to roughly 15 cases per year in a country of more than 300 million people. Under the new approach, however, those numbers could rise to between 1,200 and 2,400 cases annually. That is nearly a 100-fold increase compared to historical averages. Such a massive jump changes the entire nature of the system. What was once rare and exceptional begins to look routine and systematic. And whenever enforcement goals are tied to monthly targets, the way cases are handled can begin to change. Instead of focusing only on the most serious violations, there is pressure to find more and more files that might qualify. Legal experts warn that in this kind of environment, the definition of what counts as a problem can slowly expand. Small inconsistencies, forgotten details, or minor errors that would have been ignored in the past may suddenly be treated as serious red flags. That possibility is what is causing so much fear among naturalized citizens today because it raises a deeply troubling question. If the standards become stricter and the reviews become more aggressive, how safe is anyone's citizenship really? Under U.S. federal law, taking away someone's citizenship is supposed to be extremely difficult. Naturalization is designed to be permanent, and the legal bar for revoking it has always been set very high. The government cannot simply change its mind years later because of a new policy preference or a different political climate. To strip a person of citizenship, federal prosecutors must prove that the individual obtained it through intentional fraud or by deliberately hiding important facts during the application process. That means there must be clear evidence that someone knowingly lied, purposely misrepresented information, or used illegal means to secure their status. Honest mistakes, misunderstandings, or simple clerical errors were never intended to qualify. The law makes a critical distinction between deception and human imperfection. Memory gaps, translation problems, or small inconsistencies in paperwork are not supposed to be treated as crimes. For decades, that distinction served as a powerful safeguard for millions of immigrants who went through a complicated system in good faith. But now, immigration attorneys and former officials are warning that the way these laws are being applied may be quietly changing. When enforcement agencies begin operating under numerical expectations, the interpretation of what counts as material information can slowly stretch. Something that once would have been dismissed as minor can suddenly be reclassified as serious. A difference in travel dates, an incomplete address history, or a misremembered job title from 20 years ago could be presented as evidence of intent to deceive. And that is where the fear truly begins. Many naturalization applications were completed decades ago, often without the help of lawyers by people filling out complex forms in a second or third language. Records were kept on paper, not on digital databases. Details that seemed unimportant at the time may not perfectly match modern government files. None of that automatically means there was fraud. But in a more aggressive review environment, even innocent discrepancies can become dangerous. To understand why this matters so deeply, imagine the situation from the perspective of an ordinary immigrant family. Picture someone who arrived in the United States 30 years ago, worked hard, followed every rule, and eventually became a citizen. Over the years, that person built a career, paid taxes, raised children who were born as Americans, and fully integrated into society. Citizenship was supposed to be the final chapter of their immigration story. Now, imagine receiving a notice from the government saying that an application filed decades earlier is being reopened and reviewed again. A forgotten short trip abroad, a slightly incorrect employment date, or a form filled out in a moment of confusion could suddenly be questioned as a possible misrepresentation. Under a system that values high numbers of referrals, intent can begin to matter less than technical interpretation. Instead of asking whether someone truly tried to deceive the government, the focus can shift toward finding any inconsistency that might justify legal action. For naturalized citizens who believe their status was secure, this possibility introduces a level of uncertainty they never expected to face. The process itself can be emotionally and financially devastating, even if the person ultimately proves their innocence. Legal battles over citizenship can last years, drain savings, and create constant anxiety for entire families. Children, spouses, and communities are all affected when a parent or relative suddenly finds their citizenship under threat. What makes this situation especially unsettling is that the vast majority of naturalized Americans did everything exactly as the system required. They waited in long lines, attended interviews, submitted fingerprints, passed background checks, and trusted that once the oath was taken, the matter was closed forever. Now, many are learning that in certain circumstances, the past can be reopened in ways they never imagined. Government officials who support this new approach argue that the goal is not to target ordinary law-abiding citizens. Public statements emphasize that denaturalization efforts are meant to protect the integrity of the immigration system and to correct past cases where serious fraud occurred. According to this perspective, the focus is on individuals who allegedly hid criminal histories, concealed gang involvement, lied about serious offenses, or used false identities to gain citizenship. From that point of view, revoking citizenship is presented as a necessary tool to ensure that people who never should have qualified in the first place do not continue to benefit from their deception. Prosecutors have reportedly been encouraged to pursue these cases as aggressively as the law allows, sending a message that the government is determined to clean up past mistakes. Supporters argue that citizenship is a privilege and that anyone who obtained it through dishonest means should not be allowed to keep it, no matter how much time has passed. But critics point out that good intentions do not always translate into fair outcomes. When policies are expanded and quotas are introduced, the line between serious wrongdoing and minor error can easily blur. The risk is that a system designed to catch genuine fraud begins sweeping in people who simply made ordinary human mistakes. That is the heart of the current debate. No one disputes that true fraud should have consequences. The real question is how broadly that definition will be applied and how many innocent lives could be caught in the process. And as this policy unfolds, it is becoming clear that denaturalization is not an isolated issue, but part of a much larger shift in the way immigration enforcement is being carried out across the United States. What makes this moment especially significant is that denaturalization is unfolding alongside a much broader and more aggressive immigration enforcement agenda. In recent years, the United States has seen a series of policies aimed at tightening control over who can enter the country. Asylum rules at the southern border have been restricted, refugee admissions have been limited, and visa programs have faced new layers of scrutiny. Travel restrictions, increased background checks, and slower processing times have all become part of the modern immigration landscape. But despite their differences, all of those measures shared one important feature. They were focused on people outside the United States or individuals trying to come in. The new push toward reviewing and revoking citizenship is fundamentally different. It is not about borders, visas, or undocumented status. It is about people who already completed the entire legal process, already took the oath of allegiance, and already became full members of American society. For the first time, enforcement priorities are shifting from who can become American to who is allowed to remain American. That change carries enormous emotional weight. Citizenship has always been seen as the ultimate protection, a shield that once granted could never be questioned again. Now, even without any mass revocations actually happening, the very existence of this policy is creating widespread anxiety. Naturalized citizens are beginning to wonder whether forms they filled out decades ago could be used against them. They are questioning whether a mistake made long ago might suddenly be reinterpreted as intentional deception. And that uncertainty alone is enough to reshape how millions of people feel about their place in the country they call home. Critics warn that policies like this do more than target individual cases. They slowly chip away at the sense of permanence and belonging that citizenship is supposed to provide. When people start to fear their own legal status, even after following every rule, the relationship between immigrant communities and the government begins to change in deep and lasting ways. To understand just how large the potential impact could be, it is important to look at the sheer size of the population involved. Today, there are roughly 26 million naturalized citizens living in the United States. Every one of those people was born in another country, went through the legal immigration system, and was eventually granted the full rights and responsibilities of American citizenship. That number continues to grow each year. In the most recent year alone, more than 800,000 immigrants took the oath and officially became Americans. Each of them did so with the belief that they had reached a permanent and protected status. But when policies expand and enforcement targets rise, even a small percentage of reviews can affect an enormous number of people psychologically. If thousands of old files are being reopened annually, the sense of security for millions begins to weaken. The fear spreads far beyond the individuals directly involved in any specific case. Entire communities start to feel vulnerable. One group that is watching these developments especially closely is the Indian American community. After Mexico, India is the second largest country of origin for naturalized U.S. citizens. In just the last year, nearly 50,000 Indian-born immigrants became American citizens, representing more than 6% of all naturalizations nationwide. Many of these individuals arrived on employment-based visas and spent years, sometimes decades, navigating an incredibly complex system before finally qualifying for citizenship. They waded through long green card backlogs, renewed temporary statuses again and again, and built their lives step by step in the United States. For them, naturalization was not just a legal milestone, it was the end of a long period of uncertainty. Now, with talk of denaturalization quotas and expanded reviews, many are beginning to worry that the finish line they crossed may not be as permanent as they once believed. The emotional impact of that realization cannot be overstated. For many Indian American families, the path to citizenship was an especially long and demanding journey. Large numbers arrived in the United States on H-1B work visas, filling critical roles in technology, medicine, engineering, research, and business. They spent years contributing to the economy while waiting patiently in immigration backlogs that often stretched for a decade or more. Some lived in temporary status for 15 or even 20 years before finally receiving a green card. Only after additional years of permanent residency were they able to apply for citizenship. By the time they naturalized, many had already built entire lives in America. Their children grew up attending U.S. schools, speaking English as their first language, and knowing no other home. Homes were purchased, careers were established, taxes were paid, and deep community ties were formed. Citizenship was supposed to be the final confirmation that all those years of patience and hard work had been worth it. But under an expanded denaturalization strategy, that sense of closure is being replaced with new questions. Immigration attorneys across the country report that naturalized citizens are suddenly asking things they never imagined they would need to worry about. What happens if a date on an old form was slightly wrong? What if a short trip abroad was not recorded perfectly? What if information listed on a green card application years ago does not match exactly with what appeared on a later citizenship form? These concerns are especially intense for people who naturalized many years ago when records were kept on paper, and memories of past details have naturally faded. For them, the fear is not about having done anything wrong. It is about the possibility that normal human imperfection could be treated as something far more serious. The idea that a life built over decades could be threatened by a technical inconsistency feels deeply unfair to many who followed every rule they were asked to follow. Legal experts warn that the consequences of this policy go far beyond the actual number of cases that might ever reach a courtroom. Even the possibility of expanded denaturalization creates what many describe as a chilling effect across immigrant communities. Naturalized citizens who once traveled freely to visit family abroad are beginning to hesitate, worried that leaving the country might trigger additional scrutiny when they return. Others are becoming reluctant to interact with government agencies at all, even for routine matters such as renewing documents, applying for benefits, or correcting records. Simple everyday actions that used to feel normal can suddenly feel risky. Updating an address, reporting a change in circumstances, or filing any kind of official paperwork may now be viewed as inviting unwanted attention. Over time, this kind of fear can slowly erode trust in the very institutions that citizenship is supposed to connect people to. Instead of feeling secure in their status, naturalized Americans may begin to feel permanently on probation, as if their membership in the country is always conditional. There is also a broader concern about fairness and equal treatment. If immigration offices are expected to meet numerical targets for denaturalization referrals, will certain communities face more scrutiny than others? Will people from particular countries, regions, or backgrounds be reviewed more aggressively simply because of where they were born? Civil rights advocates warn that even if the policy is intended to be neutral, the risk of unequal application is very real. The possibility that naturalized citizens could be treated differently based on nationality, ethnicity, or profession raises serious questions about equal protection under the law. At its core, this debate is not just about paperwork or legal procedures. It is about the fundamental meaning of American citizenship itself, and whether that meaning is now quietly being rewritten. At a deeper level, this entire issue forces the country to confront a question that has rarely been asked so directly before. What does American citizenship truly mean? For generations, the promise was simple and powerful. Once you became a citizen, you were American in every sense of the word with the same rights, protections, and permanence as anyone born in the United States. Naturalization was supposed to erase the line between immigrant and citizen forever. But if citizenship can now be revisited years or even decades later based on old paperwork or shifting enforcement priorities, that promise begins to feel less certain. Critics argue that this creates the risk of a two-tier system, one for natural-born citizens whose status can never be questioned, and another for naturalized citizens who may always live with the possibility of review. That idea strikes at the heart of what has long made the United States unique. The belief that anyone, regardless of where they were born, can become fully and permanently American. Supporters of stronger enforcement insist that protecting the integrity of citizenship requires tough measures and that genuine fraud must have consequences. But opponents counter that citizenship should not feel fragile or temporary for people who followed the rules in good faith. As this debate unfolds, it is becoming clear that the conversation is about far more than individual cases. It is about trust, belonging, and the long-term relationship between immigrant communities and the nation they chose to call home. For the 26 million naturalized citizens living in the United States today, the landscape is undeniably shifting. The assumption of absolute permanence no longer feels as solid as it once did, and that emotional change alone represents a major turning point in American immigration history. In moments like this, practical preparation becomes more important than fear. Immigration attorneys and legal experts are encouraging naturalized citizens to take simple but meaningful steps to protect themselves and reduce uncertainty. One of the most important recommendations is to review old immigration records carefully. Keeping copies of every application form and supporting document can make an enormous difference if questions ever arise in the future. Ensuring that information across different filings is consistent or at least explainable can help prevent misunderstandings later on. Experts also advise naturalized citizens to be thoughtful before international travel, especially if there were any complicated issues in their immigration history. Consulting a qualified immigration attorney before making major filings or traveling abroad can provide peace of mind and professional guidance. None of this means that most people are in immediate danger. The vast majority of naturalized Americans have nothing to worry about because they obtain their citizenship honestly and legally. But in a changing policy environment, being organized and informed is always better than being caught off guard. Staying aware of new developments, understanding your rights, and keeping accurate records are practical ways to navigate this new reality without panic. Above all, it is important to remember that citizenship still carries strong legal protections, and denaturalization remains a complex and difficult process for the government to prove. Awareness and preparation, not fear, are the best responses to uncertainty. If you appreciate clear, fact-based explanations like this and want to stay updated on how immigration policies are evolving, consider subscribing to this channel so you never miss important information that could affect you or your family. As we move closer to 2026, this issue is likely to remain in the headlines, and new details will continue to emerge. The conversation around denaturalization is still developing, and many legal challenges and policy debates are expected in the months ahead. What matters most right now is staying informed, asking the right questions, and understanding the facts rather than rumors. Thank you for taking the time to watch and educate yourself on such an important topic. Stay informed, stay prepared, and I'll see you in the next update.